All right. Hello, everyone. Good afternoon. Thank you for joining us for today's webinar. My name is Gabe Groh, and I'm a member of the Saki TTA team, and I will be your host today. Before we get started, I'm going to review a few housekeeping items for you. If technical support is needed, please let us know through the chat window or by emailing sakitta@rti.org. If you have any questions regarding today's material, please type them into the chat window or use the Q&A function, and we'll retain them for the Q&A session at the end of the presentation. Please also keep your line muted for the duration of this presentation. We will archive this webinar within a few business days and also send out email announcements to all that have registered. With the housekeeping out of the way, I'm going to pass it to Lisa for some introductions.
Thank you so much, Gabe. Hi, everyone. Thank you for joining us for today's webinar. My name is Lisa Millette, and I'm a member of the Saki TTA team. This is the webinar, Achieving Justice at Trial, Direct Examination of Witnesses to Violent Crimes, presented by Patricia Powers and Dr. Rebecca Campbell. Points of views or opinions in this presentation are those of the authors and do not necessarily represent the official position or policies of the U.S. Department of Justice. Patty Powers joined Equitas after serving as a senior deputy prosecuting attorney in Washington State for 27 years, bringing extensive litigation expertise as a well-respected trial attorney. She supervised the sexual assault domestic violence unit and prosecuted and tried a high volume of violent crimes, specializing in adult sexual assault, child sexual assault and abuse, sexual exploitation of minors, domestic violence, and related homicides, including complex litigation of high profile as well as cold and current cases. Patty served on the Domestic Violence and Child Fatality Review Committees and was a member of the Washington State Technical Assistance Committee for Child Death Review Guidelines. For 5 years, she was appointed as a highly qualified expert for the United States Army Criminal Investigation Division. In this role, she provided training for Army criminal investigation agents and prosecutors at Fort Leonard Wood, Missouri, and in Germany. Patty is the lead attorney advisor on the Saki TTA project. Dr. Rebecca Campbell is a professor of psychology and presidential advisor on relationship violence and sexual misconduct at Michigan State University. Dr. Campbell's research examines how contact with the legal and medical systems affect adult, adolescent, and pediatric victims' psychological and physical health. She was the lead researcher for the National Institute of Justice-funded Detroit Sexual Assault Kit Action Research Project, which was designated as an exemplary project by the Association of Public and Land-Grant Universities and the W.K. Kellogg Foundation. Dr. Campbell received the 2015 Crime Victim Research Award from the U.S. Department of Justice. Dr. Campbell also conducts training on sexual assault for law enforcement and multidisciplinary practitioners in civilian, military, and campus community settings. And without further ado, I'll go ahead and pass it over to our presenters.
Thank you so much, Gabe, and thank you also, Lisa. Hello, everyone. I'm Patty Powers, an attorney advisor with Equitas, and I'm honored to have this chance to discuss with you, along with Becky, the complexities of preparing for trial with witnesses to violent crimes and strategies to effectively present that testimony. In terms of our work with witnesses to violent crimes, we're going to work hard to identify both direct and secondary witnesses that have information relevant to establishing the elements of the crime and also, significantly, the context of the crime as well. In that regard, it's so important that we put together complete witness lists. Sometimes when we're putting our witness list together as prosecutors and also law enforcement professionals, we look at witnesses not perhaps fully understanding how significant what now seems as minor testimony could be when the evidence develops at trial. Sometimes when we're also preparing our witness list, we look at witnesses and sometimes have a view that perhaps the evidence that one witness would give is going to be cumulative to another witness. And yet, how many times have we been in trial when a witness may not have the clarity of memory that they previously had, but another witness on the witness list does have a memory of that particular circumstance. So to begin with, we want to ensure that our witness lists are complete. And in that regard also, thanks to the work that's being done by so many allied professionals around our country, we are getting CODIS hits that are giving us information about other victims. Sometimes we're able to join those other causes in the case that we're prosecuting, and sometimes joinder is not possible, but we still have potentially evidence of 404B. And as Becky and I are both going to discuss, it's so important that we're sensitive to the victimization of these victims who are also witnesses pursuant to FRE 404B. And when we have the chance to present this evidence to a jury, it's so important that we prepare with experience-based questions when we ask these questions of direct and secondary witnesses. As we're going to discuss, witnesses are impacted by what they saw or heard or otherwise experienced. And in this process, they form a memory of these events, which we're also going to discuss. But it's going to be important also to consider utilizing experience-based questions as we offer this testimony relative to the elements of the crime, and again, significantly, the context of the crime as well. And for all witnesses, as prosecutors and allied professionals, we really want to ensure that we're providing trauma-informed support to witnesses from our initial interaction with them and all of the way through. So we're going to begin with a discussion of identifying direct and secondary witnesses, making that witness list really represent the fullest amount of witness information available. And, you know, also in that process, we're establishing the diligence of our investigation. And we look at all of the evidentiary resources that we have, forensic evidence and expert testimony to explain this evidence to a jury. Very frequently in current cases, we have digital evidence. We have a victim statement. And tragically, in homicides, we have an autopsy where the victim's body is able to provide information. The offender sometimes makes a statement and other times may make certain admissions to other individuals. We also have medical evidence. We have the statement for purpose of medical diagnosis, as well as the information provided by the victim. And we also have the medical examination. Today, we're going to be focusing on another very important evidentiary resource, and that is direct and secondary witnesses, as well as other victims. And putting these resources together, our ultimate goal is to recreate the reality of these crimes for our fellow citizens who are called to serve as jurors.
So picking up on this idea of direct and secondary witnesses, let's take a few moments to define those terms. They're terms that mean a great deal in my world as a social science researcher that can also have a lot of relevance in the legal context as well. So when we're trying to study witnesses and understand witness memories and experiences, we make a distinction between the direct witnesses, those who directly witnessed the focal event, versus the secondary witnesses who did not directly perceive the focal event, the crime that were of focus, but might have directly perceived other events surrounding the focal event. So they may have been there before, immediately after, shortly thereafter, or somewhere long-term down the road, but they do still have some information about the focal event. So let's start off by talking about our direct witnesses. Again, those who directly perceived the focal event, and in this case, the crime. So in terms of what a direct witness witnessed, we have to ask, what was it that they witnessed? It's not a tongue twister, but it is a moment to sort of pause and think through what they witnessed is going to have pretty different implications for the impact that it had on them, as well as their memories. So a traumatic thing that they witnessed means that the focal event threatened the safety or survival of the witness. or the direct witness had reason to believe that their safety or survival was in jeopardy. So this is important. What we're distinguishing here is the victim perspective from the witness perspective. It is traumatic when the witness themselves thinks that their own life is in danger from the event. So this could be a witness to a homicide, could be a witness to other types of crimes, but given the context of what they're witnessing, it is a very reasonable belief to them that their life too may be in danger, and thus what they're witnessing is a traumatic event. Now, this is different from when a direct witness witnesses a stressful event. In this situation, the focal event did not threaten the safety or survival of the direct witness, or they didn't believe that their safety was in jeopardy. But it was nevertheless very troubling, upsetting, unusual, but it was not a threat to their survival. It may have been a threat to the survival of the victim. So the victim could have a traumatic experience and the witness had a stressful experience. It's also, as I just said, it could be a situation where both the victim and the witness had a traumatic experience. So the key issues that we're trying to differentiate here for the witness is the extent to which the focal experience threatened their safety, or a reasonable person would believe that their safety and survival were in question. And then lastly, sometimes direct witnesses witness what are seemingly ordinary events. So as they're perceiving it, the focal events seem like something kind of routine and ordinary, and they didn't think a whole lot of it. I did some research once with a witness who witnessed a kidnapping of a trafficking survivor. The way it played out, it looked like a seemingly normal event. The circumstances surround that did not clearly convey at that time the criminal activity, but they became very important as direct witnesses down the road at trial. So in terms of what they witnessed has different implications for their memories. So we're going to talk a little bit about that. The extent to which what the direct witness witnessed was traumatic or stressful, the research suggests that those memories tend to be pretty accurate and stable over time, with a few caveats. So let's get into that. So as I said, these tend to be the central details tend to be stable and accurate over time for both traumatic and stressful events that they witnessed. So you can reasonably expect that a direct witness will have pretty good recall of sights, sounds, threats of the situations, particularly if weapons were involved. Those tend to be central details that are encoded and tend to be stable over time for recall. What tends to be less stable over time, so for prosecutors, you want to think about these may be the things that maybe your witnesses aren't going to have great recall on. It would be what are called peripheral details, some of the context around the traumatic or stressful event. So knowing the exact time something happened, the exact details of the scene, or being able to recall the events in exact sequence. Those are peripheral details. They're not essential to the survival, and therefore the witness's memory may not be as stable over time. In addition, for witnesses in particular, direct witnesses, the recall of that memory is affected by many different factors that it's important to understand. So first off, the passage of time or decay. For traumatic memories, that's not quite as much of a concern, but sometimes for stressful memories, we can see a little bit more decay in the crispness and all of the details, both central and peripheral, if it's been quite a while. So for those of you who may be working on cold cases, this is something you're going to need to pay attention to with your direct witnesses. The number of times that they're asked to recall or retell the event for witnesses can create some interference in the memory and the retelling. So what they have is a memory of the actual incident and then a memory of the retellings. And so sometimes you can get a little bit of interference and noise and inconsistencies in what witnesses will say from one encounter to the next when they've recounted it. So again, for colder cases, expect that there may be some additional inconsistencies. One of the things that my discipline of psychology has pretty clearly also established is that the extent to which the recall was done under a condition of stress or support will affect how much they can recall and how they retell. And the literature is very clear that giving all parties, both victims and witnesses, a safe, supportive environment facilitates recall. It doesn't promote false disclosures. It doesn't promote bad recall. It doesn't promote incorrect information. What it does, it helps reduce the stress and trauma that people are experiencing and helps them recall it better. So again, for a cold case, if you want to think about like how many years ago that happened, and if the style of interviewing was not trauma informed and it was a very terrifying, intimidating environment, the recall for your witness might not have been as complete as when you might have a re-interview later under much more supportive conditions. And then finally, there's also some research that some of the investigative techniques that used to be used by law enforcement and still are in some jurisdictions where they would purposely ask misleading questions. That tends not to be a good investigational technique. We know that now. The science on that is pretty clear. But again, for some of those older cases where that happened, some of the witness memories, again, what you may see are some inconsistencies from those first interviews where they use those techniques, as opposed to now where we now know that those techniques should not be utilized. So what about those seemingly ordinary memories? I just told you some of the boundaries and context for the traumatic and stressful memories. What do we know about the stability and accuracy of those seemingly ordinary? Sorry, folks, don't have a lot of research to share on this. We don't know as much about that. It's less common in a legal context. So if you find yourself in that situation, again, it doesn't mean that they don't remember. It just means I, as a social researcher, can't give you a whole lot of data on what you might expect in terms of the accuracy or stability of those memories over time. So moving on now to our secondary witnesses. Again, they did not see or witness directly the focal event, the crime, but they did directly perceive something surrounding it. So maybe they saw the victim before or afterwards. So what do we know about them and their recall over time? Same things that we saw for our direct witnesses. The secondary ones, the accuracy and stability of that recall, very strongly influenced by the passage of time. Again, the more salient the experience was at that time, the better the recall is going to be over time. Likewise, the number of times those secondary witnesses have had to recall, we want to try to minimize so that we're not getting interference with the event and then the recall of the event and the recall of the event over and over again. Likewise, those secondary witnesses do a much better job of recalling when they were interviewed under supportive conditions. And again, they also recall much better when we do not deliberately use misleading questions. So how might we facilitate the engagement of both our direct and secondary witnesses in trial preparation, given that what they've experienced is likely a traumatic or stressful experience? We talk a lot about this with our victims. What about our direct and secondary witnesses? The good news is much of the information is still the same. So we need to be thinking through and making it as easy and supportive as possible for our witness engagement as we do for our survivors and victims. So we want to think through the logistics. We often, lack of engagement sometimes is due to life stresses, particularly now in the pandemic. This is more important than ever. So stress and trauma also compromise problem-solving skills. So let's help everybody out with some of those problem-solving skills around childcare, transportation, technology needs. Make it easy to meet with you. Second, we want to really think through what are the expectations and make this clear to our witnesses. I often say, for a prosecutor talking with a witness or a victim, this is something you literally do every day. You know exactly what's coming. And most of you do a good job with communicating that to your victims and to your witnesses. And this is me just saying, particularly for those who've directly or secondarily witnessed violent crimes, all of this applies even more so. Help them understand what it's going to be like, what you're going to ask, help them see this. Help them understand what's coming because it really reduces their stress and anxiety. And finally, pay attention to safety considerations. Again, we think about that for our victims. It very much applies for our witnesses. This is something I'm going to touch on a little bit further in the webinar when we talk about those 404B witnesses. safety concerns are very much going to be on their mind. So think through physical safety, emotional safety, and have advocates and supportive resources available for your witnesses.
We're turning now to some of the information that Becky was also mentioning just a short time ago. Many of our witnesses, for whatever reason, are not entirely comfortable in addressing us with questions, but there are some categories of questions that we really can't anticipate that they need information about. One of them is court security. What are the security arrangements in the courthouse? What kind of security is going to be offered in the courtroom? Witnesses to violent crimes in particular are greatly concerned about the reaction of the defendant to their testimony, or perhaps there are associates or family members of the defendant who may be present in the courtroom. So if we anticipate any issues coming from any person who's present in the courtroom, this is something that, along with defense counsel, we can address with the court before the beginning of the proceedings, so that we can allay the concern of the witness by letting them know that these considerations have been discussed, that we're on this, and that we can respond if anything is to transpire in the courtroom that would impact in any way their testimony. Especially during the pandemic, there are numerous questions about the technology that's going to be utilized. In some areas of the country where the court has determined that social distancing is appropriate and really is a sustainable practice developed from the pandemic, there may still be live streaming of the proceedings in another courtroom, or there could be access through a Zoom link. Whatever the technology that's being utilized is, we need to make sure that we understand that and we can communicate those technological considerations to our witnesses, as well as, and this is very important also, the safeguards that the court is undertaking, the admonition to those who would listen to the live streaming or access the proceedings on Zoom, that there is to be no recording or no dissemination of any recording of these proceedings. Many witnesses are concerned with this kind of technology because at least they can see people physically in a courtroom, but they don't know who all may be accessing this outside of the courtroom through another platform. So these are questions, and we can provide answers to them to the best of our ability. What about the media in high-profile cases? We should have an understanding prior to the trial with the media about not photographing witnesses and not speaking with witnesses, including victims, certainly without their consent. But these are understandings that we need to have cultivated well before the trial so that we can explain this to our witness. And finally, privacy considerations. Who all is going to be able to know about my testimony beyond people in the courtroom? And we know also that most jurisdictions have public records acts, and there can be requests for transcripts. But we need to be prepared to discuss this with witnesses, and based upon the safeguards that we do have in place, to be able to assure them of our efforts to help protect their privacy. Now, as Becky has mentioned, a direct witness has sensory information, usually about the focal point, the crime that we're talking about. They may be in a position to describe details of the event in a sensory fashion, utilizing their eyes, what they saw, what they heard, sometimes what they smelled or tasted or touched, depending upon what the scenario is. And this can be very important evidence. It could be, for example, probative of the victim's disclosure. It could be probative of the identity of the offender or the presence of the offender. A witness may have seen the offender in the area or saw the offender leaving at an area at an important period of time. Another example, a witness may have seen a victim run from an area or out of a room, and the victim appeared very upset And they then saw someone else, a man, emerge from the area from which the victim had just come. So a direct witness may have this kind of focused information. Compared to a secondary witness essentially can provide information from which we can infer or provide a foundation for an inference from an observed fact. And this can also be corroborative of important aspects of our cases as well. The example that we see so frequently in sexual assault cases is testimony from a friend of the victim who saw and observed the victim in the days or weeks following the crime and was struck by how different the victim presented, how her attire, her demeanor had really changed substantially. And this witness may testify that they were impacted by what they saw in this regard and felt like something bad had happened to the victim. In a sense, 404B witnesses are also secondary witnesses, but they can provide invaluable information that can suggest similarities in the offender's conduct or other relevant evidence. So let's start with a discussion of direct witnesses to violent crimes. And our preparation with them, as Becky has mentioned, is so important. We need to provide them with the support for what we're asking them to do in the criminal justice system. They may have seen, heard, or otherwise experienced the crime or a closely related event. And Becky has already described to us how this may be categorized as traumatic or stressful. And what we want to bear in mind is whatever the witness saw or heard or otherwise experienced that has impacted them in a way that they have formed a memory from what that experience is. So as prosecutors and allied professionals in a trauma-informed way, and we're going to keep emphasizing that because it's so important, we want to ask sensory questions to enable the witness to access their memories of the event. And so we're going to ask them what they saw or what they heard, what they smelled, touched, or tasted. And we're going to ask them about their response to that experience, how they felt when they saw, for example, what they have described to the jury. We also want to go on, and I think this is a significant but sometimes overlooked part of our work. We want to determine if the witness has spoken with anyone else and the reason for the conduct. As Becky mentioned also, this may impact their recollection of the information that they initially had experienced from the crime or from the focal point. Also, it can give us, as prosecutors and allied professionals, additional information, not only about the impact on the witness, but potentially other witnesses. For example, if a witness who had heard what they believed to be rounds being fired from a gun, they heard gunshots, and they were alarmed by this in an otherwise peaceful neighborhood, they may have spoken with their significant other or a close friend or a neighbor. Did you hear that? Were you around when that happened? And in that process, we get additional information about the impact on this specific witness. And we also have learned of the identity of another witness, especially if the memory of our initial witness is going to be called into question and there's a claim of inconsistency. So this kind of important information is really necessary in terms of our investigation. And we also want to find out whether over any period of time, the witness believes that they have remembered additional details that were not originally supplied. And obviously, as we all know, we provide this information to the defense as well as that initial statement. That's a very important part of our discovery obligation. But we also want to find out more. If the witness is recalling additional details, what was the context of the witness recalling these additional details? What helped or what caused this additional detail or memory to surface? And this becomes very important to us as well. And then, of course, for foundation, We always want to establish the location of the witness in proximity to whatever they observed or heard or otherwise experienced. We want to know whether there were any impediments, whether there was any other sound or noise going on in the area. And the reason that we're doing this is that we want to be able to accurately present this witness to a jury so that the jury, the ultimate trier of fact in the case, is in the best possible position to determine the viability of the testimony. Now, when we meet with witnesses before trial, it's very common for witnesses to ask for an opportunity to review their prior statement. And if you think about it, this makes a lot of sense, doesn't it? If we were witnesses and if we had given a statement, we may want to read that again. And so this certainly is something that we can be helpful with and allow, unless there are some restrictions that have been previously imposed by the court, to allow the witness to review the statement. We also need to consider that it's very likely that the witness may be asked about their prior statement during cross-examination. And we want our witness to be in a position when they see that transcript to recognize it, to have had an opportunity to review it. As we all know, there are times when questions where a witness may have their attention directed to a certain question and answer, but there's considerable context around that, right? And so having given our witness an opportunity to review that previously can be helpful to them. Many witnesses have questions, as Becky already has advised you, about not being able to remember everything, not being able to remember the exact date when this happened. And, you know, that's a very common concern of witnesses, but we're in a position to let them know that the date is going to be established through other evidence. There'll be law enforcement professionals as well as other individuals that will provide testimony, will provide evidence in that regard. We may want to ask the witness if they recall a time when they either contacted law enforcement or spoke with law enforcement. And that's something that most witnesses remember. It's not an everyday event to feel the need to contact law enforcement or to be contacted by them. And generally, that can be a pretty good touchstone, if you will, to remember the basic context. We also want to inquire about any circumstances leading up to the witness's contact or interview with the police. Had they discussed their observation, for example, with anyone else? Are there any other life stressors that they were undergoing during this period of time? And again, what we're trying to do is to have the most accurate picture of how the witness remembered whatever they remembered from the event, if there were any intervening activities that we should inquire further into. And what was their emotional state? How did they feel when they saw what they did and later spoke with the police? All important details in terms of our preparation and also in terms of trial testimony. Now, when we talk about the foundation for testimony, these are the basic questions that we ask so that the jury will come to know the individual that is testifying and also some basic information about them. And so for the most part, we're going to be asking about their name, their length of time in the community, if they are employed, and we'll know that from our previous contact. Otherwise, we wouldn't ask it, what their current or previous employment as relevant was. Do they have a recollection of the day in question, including the events prior to and subsequent? In other words, we're not going to just be asking the witness on this particular day, or do you remember a time when the police spoke to you about a certain day? What did you see? We're going a little bit further out. We're kind of spanning out, if you will, to what had you been doing prior to that time, laying the foundation for what they're able to share with us. There may be some additional reference points that we can also find out from our witness. During this period of time, some of the examples might include the witness remembers that because it was their birthday, Maybe they had just moved into a new home. They were going to start a new job and they were concerned about that. Or maybe a family event or something that had impacted a friend. But many times they can give us a reference point that they use to help them to remember the particular time. And then the language, and I think this is so important. And when we talk about working with victims and presenting the direct examination of a victim, we've talked a lot about asking the question, what are you able to tell us? We can also frame the question that way for witnesses. What we're doing, we're telling them without even using all the words, this is quite an experience to be here on the witness stand in a very serious case, being asked these questions by attorneys going back to a much earlier period of time. We don't even need to say that, but we can say, what are you able to tell us? And this essentially is an opportunity for the witness to provide a narrative, and it takes the burden of the chronological detail out, which, as we know from the information that Becky has provided, some witnesses are not going to be able to provide this kind of detail. If one of the questions that's going to be asked of the witness is whether or not they can identify the defendant, we also need to be very familiar with the work that was previously done. Was there a lineup, or was there a photographic montage or array of photographs that was presented to the witness? Was the witness able to make an identification during that period of time? Did they circle and or initial that selection? And we should have that evidence at hand from the investigation. Is the witness able to articulate, if relevant, any features that they may have based the identification upon? Some witnesses may recall a certain body size. Some may recall certain facial characteristics. Some may recall wire rim glasses. A number of different focal points may support a witness's identification. The reason why we're asking this, especially in a cold case, we want to be able to provide other evidence about the appearance of the offender during earlier times. And just as an example, if an offender was wearing wire frame glasses, and this is something that the witness had focused on, then we might be able to access in the investigation, like Department of Licensing photographs from earlier times. But it's important because it gives us a path to corroboration. Preparing for the potential of physical changes over the year. We know in cold cases that obviously has occurred, but we need to make sure that we're allowing victims the opportunity to be uncertain if they are. If they can't identify someone, then they can't identify someone. It's not a cause for concern. The focal point of all of our work is ensuring that testimony is truthful. And we might want to ask the witness going back in time to describe the circumstances and the initial view they had of the suspect during an earlier time. Again, this is a resource for additional corroboration. So when we talk about asking our witnesses experiential details, I really want to preface this with how important this is, not only for the witness to allow them an opportunity to access their memory, primarily when they are traumatized or engaged in a stressful response to an event, but this also is a critical connection point with our fellow citizens who are jurors. They will listen to this testimony and they will utilize their own experience, their own life experience, the use of their senses. And they do this in an effort to relate to and to assess the viability of this testimony. So it's a very important connection point for jurors as well. And we're asking questions of the witness about what they saw, heard, if they smelled anything distinctive, if they tasted anything, or if they touched. Then we're asking how they felt when they had that experience. And sometimes we'll hear an emotional response. Well, I was scared to death. Those were gunshots. I've heard them before. And I didn't know what was happening, but I ran back to my apartment. I could barely breathe. Now, in that statement, we have a sensory description with an attendant emotional and physiological response. We may not always retrieve this information, but it's important to ask the witness if they're in a position to provide this information to us. So when we talk about conducting a complete direct examination, it sounds sometimes easier than what it is, but we need to be focused on asking all necessary questions. That means really looking toward what our goal is in calling the witness, the evidentiary support we have for this testimony from other direct and or secondary witnesses. And we also want to anticipate probative questions from cross-examination. Now, we're not going to ask irrelevant questions that we think may be asked and that we're going to object to, or we already have pretrial orders in limine that they shouldn't be asked. But if there are reasonably probative questions on cross, we're going to incorporate them into direct. Our goal is to present the fullest amount of evidence possible to the jury with this witness and every witness. And, when we think back to preparing a complete witness list, as I mentioned earlier, sometimes we overlook how significant these witnesses are. And yet, isn't it interesting when this witness takes the witness stand, this is the most important person to us, to the defense, and to the jury. That's the level of preparation that we need to bring. And one of the questions that's very frequently asked by defense counsel, we should definitely establish on direct, and that is about all of the interview contacts that this witness may have had with law enforcement as well as the prosecutor. There's nothing wrong with working to prepare our witnesses. There isn't anything wrong with law enforcement interviewing witnesses. It's fair information, and it can appropriately be made known during our direct examination. If there was, over any period of time, additional information provided, we already would have given that discovery to the defense. It's an important part of our work to ensure that the defense has all of the information. Detail is amazingly important. The more detail that a witness is able to provide, really, the more effective the testimony. And I say this in two senses. First of all, the detail can really help a jury to assess the viability of the statements as well as the credibility of the witness. And the detail also is something that can be cross-corroborated among other witnesses. So we have other means of supporting the testimony of this and any other witness. We're going to ask for details, as we both mentioned, about what was seen and what were heard. Was there any obstruction or any impairment that the witness had that impacted their vision or their hearing? The memory that they have of the day, the time, or the time frame, or the time of day, and any other surrounding events and aftermath are also important. And then there are times when witnesses sometimes record or memorialize what they have seen or heard. It could be in a diary, it could be in another writing, it could have been in an email to a friend. And this is evidence that we would have accessed in response to this question and provided if it was still extant. I want to touch just briefly on opinion testimony by lay witnesses, because, I think we do this a lot and we don't always necessarily go back to the rule. First of all, the lay witness is not testifying as an expert, but they do have an opinion, and the opinion needs to be rationally based on the witness's perception. So we're going to discuss that in terms of other indicators, how far away they were, whether there was any impediment, is there any other sound or noise that would somehow have impacted their ability to hear this as accurately as possible. It's also helpful to understanding the witness's testimony or maybe determining a fact at issue, but it's not based on scientific, technical, or other specialized knowledge. So as an example, we're talking about a witness who personally observed an event or heard an event, and we're going to establish what the lighting was like, the time of day, or any lighting that might have been apparent in that vicinity, the sound or the weight associated with that, and whatever the distance might have been. These are all questions that may be singularly relevant in terms of this kind of testimony. If there is a view of an individual of interest, what that person's appearance was, what the witness was able to see, and if an identity was known. But all of this opinion has to be grounded in a rationally based perception. So we're talking about perception and the use of rational, putting these two together, that becomes important for foundation. So let's touch on secondary witnesses, who often are able to provide us with contextual evidence. And when we talk about the admissibility of this evidence, we have evidentiary resources, including res gestae. This could be events or statements that are inextricably related to the crime. They're part of the crime, and they fairly can be focused on in terms of evidence. 404B, we're going to talk about 404B witnesses. Sometimes we're able to offer these witnesses to prove it could be identity, opportunity, intent, common scheme or plan, or other bases. This is not an exhaustive list. As we all know, there could be others as well. And also, secondary evidence could help us establish the date or evidence of the commission of the crime. So some examples of secondary evidence from witnesses: it could be knowledge of the offender's presence at a certain location. We all went out to a tavern on that particular date. I was sitting at his table. Any activity associated with the crime could be also the subject matter of secondary witnesses. Activity associated with an exit. He left the tavern. We were all still having a few drinks, and he was gone. And I don't know why he was gone, but I also noticed that my friend, who ultimately is the victim in this case, that she wasn't there either. So I don't know if there was a connection, but I know they were both gone, and my attention was drawn to that. Knowledge of the offender's contact with the victim. This may not be directly associated, but from this evidence, we can make other important inferences. So these witnesses may not have observed prior or subsequent activity, but still have information that could be probative. We want to also, even with secondary witnesses, I think it's important to still determine the impact of information on the witness. Why does that stand out in your mind after all of this time, if it does? So, and it's interesting, I can think back to cold cases that I had an opportunity to prosecute. And one of the most common statements that witnesses offered was, "I will never forget what I saw. I will never forget what I heard." And then we would start to ask them questions, why that stood out on their mind. Why was that important? How did you feel when you saw or heard that? And again, as we've been talking, we want to try to obtain as much detail as we possibly can, because again, this can be a source that will lead us to other corroboration as well. So when we establish a foundation, knowledge of the victim, as an example, we want to find out from the secondary witness how long they've known the victim, whether they know the victim in a way that they're acquainted with how they usually present, what their demeanor usually is in most situations, how do they dress, what is their style, what is their social involvement? Are they a person who seeks social involvement or social engagement, or someone that maybe does not as much, who is more shy or more reserved? And then we want to, after we've laid this kind of a foundation of knowledge, we want to then segue into asking if the witness recalls the time that they saw the victim during whatever the identified time frame is, asking you to assume for purposes of your testimony that this particular period of time. And then the question is going to be asked, did you see her then? What, if anything, caught your attention? And did you have a conversation? Now, ordinarily, unless it's an excited utterance, which this example would not be, we would not be entitled to present evidence as to what the victim responded. But we certainly can present evidence as to what the witness said and what the emotional bearing or response of the victim was. In cases where there may be a claim of inconsistency, we still want to know what the victim said, and that might become useful at a later period of time. So the foundation for this kind of testimony prior to the event, it can help us with a timeline. We may be able to establish the presence of the offender at a certain location or event, as well as the presence of the victim. After the event, we're still looking at the timeline. That's part of the context of the crime. And so in this regard, we might be talking about the presence or absence of the offender, or anticipated contact or contact with the victim. And so we really need to dive beneath the surface to really come to understand the value of every potential witness and what assistance they might be able to offer. So we're going to turn now to Federal Rule of Evidence 404B witnesses. This is the rule. All of our jurisdictions have similar rules, and we know that we cannot offer and do not offer evidence of any crime, wrong, or act to prove a person's character. That's not admissible, or to show that on a certain occasion the person acted in accordance with their character. But these are the permitted uses, and it can be admissible for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Remember, though, this is not an exhaustive list, and that's really important because we're seeing a lot of variation in patterns from serial offenders, and it's important to know that there may be other pattern indicators. And so here we just see the layout of other acts evidence, allowing us a focal point. But we want to dive deeper. As I mentioned, there's a lot of variation among sex offenders and any patterns. So we want to try our best to recognize any physical and behavioral evidence of predatory conduct. As an example, is there a focus on vulnerability or certain aspects of vulnerability of victims? Is alcohol used in either grooming or encouraging or sometimes coercing a victim to drink alcohol, relying on the social misperception that this may impact credibility? So taking a deeper dive into evidence, still relying on 404B, but looking even deeper is especially important now. And it also can give us additional insight into the intent of the person accused, the victim selection process. And this can almost be premised on access. The victim was there in a relationship, in an acquaintance, or geographically available, if you will. There was either known or ostensible vulnerability. And the offender, drawing from social myths and misconceptions, may believe that there's a credibility issue that's built in. That's not how we view it as allied professionals. We're talking about what offenders, how they build their impression of victims and whether or not they're going to be able to succeed. What was the planning that went into this, in addition to grooming? Was there isolation? Was stalking involved? And this can also give us very valuable information about premeditation and planning as well. And what was the exit strategy? You know, when I had the privilege of working with so many victims, when I prosecuted sexual assault cases and tried a high volume of them, not always did the offender need to directly threaten the victim. That threat of serious bodily harm, and for most, if not the majority of victims, was death. And that was a fear they lived with throughout all of the period of time when we were working on the case, and I know well beyond that. So there is a broader perspective for serial offending, as I mentioned. We should consider that a rapist has possibly done this before and may go on to offend in the future. And again, thanks to the Sexual Assault Kit Initiative and the work that Becky and many other professionals in this area have done, we know that we're dealing with both offenders who assault victims they know, as well as victims they do not know. And in terms of variation, they often exhibit intraserial variations in victim relationship, age, and even gender. That's why we're encouraging all of us to take a look at 404B, but to think beyond it and to really keep our vision open to other differences that may still be encompassed by that rule. So in terms of pretrial with evidence rule 404B, if at all possible, what we want to try to do, and again, we've provided all of the available discovery to the defense, we want to try to make an offer of proof if the court will permit us to do that. This allows the court and counsel to hear the substance of the testimony without bringing the victim into court. We want to limit those occasions where the 404B victim has to testify, and we certainly can do this in many jurisdictions during pretrial. And we need to be ready to argue the commonalities in the offender's conduct, as well as the tactics utilized in causing victimization. And again, that list is not exhaustive. There may be other similarities that we can still offer. It may be the use of alcohol, it could be stalking conduct, and there are many others. So when we prepare with 404B witnesses, they are victims, and we're going to conduct a trauma-informed interview. We also want to determine the admissibility of the evidence as well as the basis, because we want to make sure that the victim that we are calling, the 404B victim, knows what the parameters of testimony are. And we have to be able to discuss that. These victims may be able to provide us with additional insight that we did not obtain from the reports, and there may be additional evidence to share with counsel and also bring to the court's attention. But we want to, when we're preparing this, identify the specific details that corroborate the primary victim's testimony and possibly also other 404B witnesses, victim witnesses' testimony as well. When we do this, we need to consider issues that we may have. If these cases were joined and there was an issue with joinder, if the offender has confessed to one particular crime or admitted to one sexual assault, the court is going to inquire into the relative strength of the individual cases. And if these are 404B witnesses, there still is going to be relevant analysis in these areas. Although the defense very frequently will propose a cautionary instruction, as prosecutors, we should do that also. Because we want to make sure that the jury only considers the testimony of the 404B victim witness for the specific reason that the court is allowing us to present it. So when we talk about calling 404B witnesses, we're talking about calling victims. Regardless of when these crimes occurred, they are victims, they are traumatized. And we need to know that from the beginning of our relationship and engage in a trauma-informed approach at all times. Advocacy support is critical. We should offer that, and if the victim chooses, make sure that that is available. We also know the questions that victims want to have. Is this person still in custody? What are the safety considerations that you're going to be able to provide in the courtroom? Is there any additional security? All of this information is going to be critical to the comparative wellness of these victims to be able to take another courageous step and come back into court.
So with that, I want to bring a little bit of perspective from the research side. to fill in some of the material that Patty's been covering and share with you some current work in progress that my research team here at Michigan State University and I are doing on 404B victim witnesses. With the discovery of so many untested sexual assault kits in many jurisdictions in the SACI project and having those kits being tested, and through the use of DNA matches, we are seeing more serial offenders, and we are having opportunities for 404B witnesses. Again, it's been there for a very long time. I'm not an attorney. I'm not saying that this whole concept is new, but its salience, if you will, is becoming a little bit more focused in the cold case sexual assault arena. So we've been, as a social scientist, as a psychologist, I've been asked by so many, practitioners who have these kinds of cases, like, can we do this? I know I can legally, but should I? What is the survivor's experience? So that's what our research team is trying to understand is when survivors are asked to participate, what do they say and what is their experience? And what we find very, very clearly is that how a 404B victim witness defines their experience as a witness depends very, very much on what happened in their own original case. If their case was still within the statute of limitations and they could participate in their own case as well as the other case, it really is double the stress, but more often than not, they experience that as a pretty powering experience. However, if their case was beyond the statute of limitations and they could only participate as a 404B witness, that's a very different situation, that they feel very conflicted, they feel frustrated and betrayed. They still, in every case that we've studied in our project, they've still been willing to support the case because they still want justice, but they are carrying some very, very heavy mixed emotions about that. There's a lot of sense of what we call in the social science world institutional betrayal, that the criminal justice system didn't help them the first time through. Their case timed out. They don't have their path for justice. They want to help their sister or brother or whoever, survivor, but it is a very, very complicated process for them. Next slide. So the court testimony is a reactivation of that traumatic memory. So they're going to need the same advocacy and support as do all victim witnesses. And one of the things that's coming out very, very clearly in our research is that 404B witnesses are highly concerned about their safety and potential retaliation, to which I'm sure every prosecutor here is like, yes, of course, that's always, a concern. I'm trying to tell you as a social scientist, this is something different than what I've seen too. Okay, the concern is that from what they're worried about is from the offender's point of view. The 404B victim witness went out of their way to make sure that he went away or she went away or whoever the offender's gender may be. And again, in the case where there was both an original case that wasn't SOL timed out and a 404B, there's doubly concern of like, wow, you really went above and beyond the call of duty twice to try to make sure this person was put away. But even in cases where the statute of limitations was expired on the first case, on their own case, they are very, very concerned not only about the offender, but the offender's family, associates, and others, really having that lens of you have an axe to grind. You really wanted to punish this person. You are an awful human being. And we do have instances where 404B witnesses did receive harassment, threats, and intimidation in that vein of, you didn't have to do this. You could have kept your mouth shut and you didn't. So there's an extra level of safety concerns. I'm happy to say that in the jurisdictions that we've studied, the prosecutors very much in the advocacy rose to the task to handle these emergent issues. But for those of you who may not have had that happen yet, I really wanted to flag this for you. So when you hear them being concerned about safety, this is a little bit different, and it seems to be perceived differently by offenders and their families.
When we talk about 404B, in addition to those very important considerations that Becky just addressed in working with 404B victims and acknowledging the trauma and the level of fear that they have of the offender, particularly when they have previously testified and are testifying again. We want to also think in terms of effectively offering this evidence to a jury. And I think one way that we have of approaching this that's especially effective is to focus and really emphasize the pattern of conduct throughout all of the 404B witnesses, as well as the primary victim, and allow the jury the chance to connect the dots. They're continually hearing reference to certain dimensions of conduct. They're hearing it again from another witness. They're hearing it again in our closing argument. And it's amazing. You can watch the jury and almost sense internally how they are putting this together. Let them connect the dots. And we need to remember that the court might reconsider the admission of 404B depending upon how the evidence develops at trial. We've all had cases where the court, considering the potential of prejudice to the defendant, even though there's probative value, may not allow 404B in our case in chief. And then the evidence shifts a bit, and perhaps the defendant testifies and opens the door to that. So we need to be ready and still have control and access to that information. And we would preview this with the court and ask the court to reconsider that prior ruling. And there have been times when we certainly can bring it back in and the court permits it. That cautionary instruction is really important. It is brought in the best interests of justice because it's important to all of us as prosecutors and allied professionals that the jury considers the evidence for the appropriate purpose. We don't want any juror ever stepping outside of a cautionary instruction and considering it for a purpose that the court is not authorizing it or considering it as somehow as evidence of character. We would never argue that, but having a well-drafted cautionary instruction is really important. So going forward, I think it's so important to identify all witnesses, whether they're direct or whether they're secondary, determining what information they have that's relevant. And when we first are reviewing police reports, particularly in cold cases, how many times have we looked at a series of interview contacts, but there haven't been formal statements, and then somehow we surmise, well, they may not have had information that was important. That's why there wasn't follow-up. We can't be that sure. We need to follow up with the witnesses, to obtain interviews from the witnesses, to look to what they are able to tell us that may be helpful in corroborating the elements of the crime, or importantly, the context of the crime. And we're talking about both direct and secondary witnesses, and they all need to be indicated on our witness list. As I mentioned at the very beginning of our time together today, sometimes one witness may not be available for trial after a prolonged period of time, but another witness may. And we need to have those people on our witness list. What sometimes appears as potentially cumulative evidence may not be cumulative at all, depending upon how the evidence is presented and the memory of the primary witness that we're going to call. And so I guess the theme is we need to be ready. And this is also so important because it helps us establish the due diligence of our investigation, which is important to the state, to the victim, or to the surviving family, to the defendant, and to our community. We want to do our level best to bring forward all probative evidence in violent crimes. And recognizing the sensitivity that we need to bring to preparation and testimony of all witnesses, but especially the 404B victim witnesses. And Becky provided us so much great information about working with these witnesses and about the traumatic impact of the crime. And it simply does not go away. It's going to be directly at the surface when we ask these victim witnesses to come into court in the presence of the offender who had victimized them. There is a high level of fear. Fortunately, there's so much we can do as a team, as prosecutors and allied professionals, with the benefit of working with professionals and experts such as Becky and others in this field. We can come to learn more and more about the crimes and about working with victim and witnesses to really engage in a true trauma-informed approach. And that doesn't stop at trial. At trial, direct examination of these victim witnesses and others is still trauma-informed. We're allowing them an opportunity to describe their experience of the crime in as much of a narrative as the court will permit. You all know your jurisdictions really well. Sometimes the court will not permit much of a narrative, but we can still try to introduce that. We can still ask open-ended questions, and we can always introduce it with, what are you able to tell us about what happened 20 years ago? And amazingly, there will be a wealth of evidence that victims are able to provide after we've given them the trauma-informed support that they deserve. And so we'll conduct our examinations using experience-based questions with both direct and secondary witnesses, because we're really giving the jury, in that regard, a glimpse into how these witnesses were impacted by whatever their experience was, directly or in a secondary fashion, enough so that they formed a memory. And in many cases, those memories are still residual after prolonged periods of time. But at the heart of all of our work is teamwork. It's working together. It's learning from each other and providing trauma-informed support to all of our witnesses throughout our proceedings. It's in the best interest of our case, and together the work that we do is in the best interest of the work of justice. So we've tried to carve out some time in the event that any of you had questions or comments.
Thank you so much, Patty and Becky, for presenting with us today. If folks have questions, please go ahead and type them into the chat pod or into the Q&A pod, and we will get those addressed. And in the meantime, while folks are typing in their questions, we're going to go ahead and launch some polls. If you wouldn't mind taking the time to answer these questions for us, we would really appreciate the feedback. And you should be seeing those polls now. And Patty and Becky, it does look like there's a couple comments that some folks made in the chat here. If you have anything to say, speak about those. And then we do have one question. What can we do as investigators? What can we do as investigators help the prosecution?
I love that question. Thank you so much for asking it. In terms of an investigation, we're looking to obtaining the fullest amount of information possible, relevant to the elements of the crime and relevant to the context of the crime. In that process, we're laying a foundation so that investigators and prosecutors, and possibly consulting with other multidisciplinary professionals, can determine if we need additional work in any of those areas. But with your help conducting the fullest possible investigations, it's the critical beginning point for the work that we all do as allied professionals. Thank you so much for that question.
Thank you, Patty. We have another question. Has any of your research involved cases in the federal system?
Nope, not yet. It's all been in one one state. None of them are federal cases, and I can feel some of you typing right now. Where is it published? When are you going to have it? It's not done yet. I was trying to be clear that it's hot off the presses, but I also am very cautious. I do not share findings in any dissemination venue, including webinars, unless I'm very sure of the findings. I'm very sure of what I said to you today. We are working on the publications from that, and as soon as they are available, we will be sharing them with the SACI website, the SACI TTA team, and we try to get all of those things up right away.
Thank you, Becky. And it looks like we do have a question about receiving a copy of the slides. We will archive this webinar and within a few business days, and that will include a recording of today's presentation as well as a copy of the slides.
And also, I'd mention that if anyone has any follow-up questions, I've got our contact information on the screen right now. We'd love to hear from you. We'd be happy to support your efforts with any additional information. And so I hope to hear from you.
Thank you so much, Patty. And at this time, it looks like we don't have any more questions coming in.
One more, Lisa. I'm
Oh,
sorry.
we do.
Yeah, I didn't mean to interrupt.
Oh, no worries.
We had a question from Roland. When is the 404B evidence introduced on cross of the defendant during the prosecution's case in chief? That's another great question. Thank you so much, Roland. We would, if the court is permitting us to do it, and we would have achieved that ruling during pretrial litigation, we'd present it during our case in chief. There may be use also for evidence that's been testified to at other parts of our case, but primarily it's the case in chief. Now, if the court is not allowing us for whatever reason to present 404B evidence in our case in chief, we need to listen carefully to how that evidence develops from the defense. If the defendant, for example, takes the witness stand and says certain things on the witness stand, that may obviate a change. And so what we would do at that point, not in the presence of the jury, we'd request an opportunity to address the court and ask the court to reconsider the ruling and allow the presentation of that evidence. So I hope that's helpful.
Thank you, Patty. And did you see the question, can I have your thoughts on the risk of ineffective assistance of counsel claims when doors open for 404B?
Okay, I didn't, we're talking about ineffective assistance of counsel on objecting to 404B. Is that correct? I don't.
So the question reads, can I have your thoughts on the risk of ineffective assistance of counsel claims when doors open for 404B? And Matt, if you wouldn't mind clarifying, Patty, if you need more information.
Okay. What I believe we're talking about, and another great question, is if the court has ruled that 404B is not admissible in our case in chief, and if we have a good faith argument to make for reconsideration, we would bring that to the court's attention outside of the presence of the jury. Now, that's going to be argued by the prosecutor as well as counsel for the defendant, and the court is going to reach a ruling. And if the court determines that it is allowable, then the prosecutor has the opportunity to present it within the confines of the court's ruling. So if there's a claim of ineffective assistance of counsel, I think we're talking about appellate litigation. Certainly the appellate court is going to look to the record and look to the arguments that are made and reach a determination based on that. That would be how I think it's approached.
Thank you, Patty. And he added, I sometimes see a risk of getting into 404B because allowing it to happen is sometimes because of a mistake on the part of the defense.
Right. You know, but as prosecutors, we have an opportunity to, in good faith, really build a strong record. And we do that, as I mentioned earlier, we might ask the court to allow us to make an offer of proof based upon the discovery of what the testimony would be. We're going to brief it. We're going to advance applicable case law. Certainly, defense counsel has an opportunity to object, to argue that, or to present any evidence that they deem appropriate. Then what I think is really important are the findings of fact and conclusions of law. In many jurisdictions, the prosecutor will put those together for the court's consideration after they've heard the argument from the defense. But I think it's so important to really carefully draft those findings and conclusions to reflect the court's decision, as well as the court's findings as to conclusions of law. And that, I think, helps us to have the strongest possible record for appellate purposes. Thank you for that question.
Thank you, Patty. And we do have another question in the chat. What is the most creative use of other act evidence that you have seen successfully used?
Becky, did you want to go first on this, or?
No, sorry, my area of expertise in this is pretty narrow. I'm going to defer to you.
Okay. We have heard from individuals that are really isolating some other features, and there is discussion that I know of about the use of alcohol, sometimes the use of drugs with alcohol. I think we're also getting better at isolating some behavioral conduct as well. I think stalking is clearly a great example of that. And it may be stalking that may not fit in with a particular state statute and be prosecutable as such, but it's the kind of conduct that is undertaken, if it's been undertaken in other cases, in very signal ways, I think that would be an area as well. But the point I think also that we want to make is what we're learning, thanks to the work of Becky and others in the Sexual Assault Kit Initiative. We're learning about the variations and patterns from sex offenders. So we need to continue to consult with experts to make sure that we're viewing this and really being able to isolate signal aspects of serial offenders.
Thank you, Patty, and thank you, Becky. At this time, it doesn't look like we have any other questions, but as the presenter stated, the contact information is on the screen. If you have any other questions, please feel free to reach out to them. Thank you all for participating in our poll questions. We really appreciate your feedback. And again, we will archive this webinar within a few business days, and we will send out an email announcement to all who have registered, and it will include a PDF of the presentation as well as the recording. Again, thank you so much to our presenters and everybody who attended the webinar today. We hope you have a great rest of your afternoon.
Thank you all. Take care.
Thank you all so much for the opportunity.